You've been charged with sexual assault and it's day 4 of your trial. The Crown just completed its case. You have a decision to make with your lawyer. The lawyer will help you make the decision. Should you testify? Should you call defense evidence? Should you call evidence other than you testifying as well? This is a very loaded question. Every case is different. As a defense lawyer, during the trial, you're cross-examining witnesses, you're cross-examining the victim, the complainant, the police officers. And each day as the trial progresses, you're asking yourself, have I created a reasonable doubt? Is it compelling at this point? Or is the complainant sounding very good? Are they credible? Are they reliable? So at the end of those 4 days or 5 days of testimony, of evidence from the Crown, when they close their case, you have a picture in your mind whether you need to call your client or not. Now, in most sexual assault cases that I do, and I would say most lawyers do, they tend to call their client. Because the way our firm operates, we will prepare that client to testify for hours. In a sexual assault trial, I mean, first of all, this is often a 2-year process leading up to the trial. I have met with that client literally dozens of times. I have prepared their testimony. We've got a statement from them. It's been poured over. I've done mock cross-examinations. I know they're going to be a good witness because we keep doing mock cross-examinations until they become a good witness. There's no other way to win a trial. See, don't confuse court with who's telling the truth or who's lying. It's about who comes across the best. A lying complainant can come across very well. A truthful complainant can come across as a liar because they're nervous, anxiety, they're screwed up. It's a weird situation, but never confuse what goes on with court about who's telling the truth or who's lying. I have had clients who I thought were truthful, who just have anxiety and can't testify. I've seen it, so it's a very delicate situation. So at the end of the Crown's case then, should my client testify? I will take a break. I'll ask the judge for a break. I'll meet with my client. I'll review the evidence with him. I'll say, look, I think we have a reasonable doubt here, but it's too risky for you not to testify. I know you're going to do well. You're prepared. Let's get you up there. That's my advice. It's their decision. They usually follow it. And I've never regretted that decision when we call it. Not in one case I've ever done, because, the only time I will not call a properly prepared client is when I'm absolutely convinced that there's enough reasonable doubt we win the case. But that's a decision, that's an awful decision to make, because if you make the wrong decision, you've lost. You don't get a chance to call your client and you'll kick yourself. So I've always err on the side of caution unless it's compelling. And I've had cases that are compelling. I know the judge is totally tuned out by the end of 5 days. You can tell they're literally asking you really need to call this witness to waste another 2 days in court, Mr. Kruse? Well, you know the answer to that. So it's the bottom line is every case is different, but I would say for most of the sexual assault cases I've done in my career, which is dozens, I don't even know how many I've done, it could be 100, I've tended to always call my client, except in very rare circumstances, a very, very compelling reasonable doubt where I had no doubt that the judge was going to acquit. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.